You guys hear me?
Yes.
Yeah, we can hear you.
Something's going on with my camera. I'll have to leave and try to rejoin the group.
Can't see you. Yeah.
Yeah, something weird going on with my.
A little bit of, did you guys get some distortion too, or was that just me?
I did not, Your Honor.
It must have been our speakers.
Okay, we're.
Wait a minute. Yeah, we got the jail there. Adam, we don't have yet video. Are you Mr. Barr? Okay. Wait a minute.
Judge, I'm here. For some reason, my Zoom says it's unable to detect a camera. I don't know what's going on.
Go to your profile, and sometimes I had that problem happen with me where I didn't have video. I had to go in there and turn it on. Because if you're hitting share video,
Yeah.
then it shouldn't be showing, so that seems to indicate there's an issue with your video setting.
I guess we're gonna have to jump on a different laptop, Judge.
Okay. Alright. Okay. Alright, you're muted there, Mr. Kane. Alright, there we go. Should be okay. No? Okay, you're on, but it shows that you're muted. You just need to click on the mic, unmute. Or up in the corner, unmute. Now you disconnected video. Should be easy to unmute. Yeah, down left hand corner. Or up in the right hand corner of the panel. Video. Okay, your video's back. There's an iPad's in the way here. This is on the call, right? You can do that twice. It's a different one. Yes, according to my screen, you're on twice. You got two laptops there? I don't see Adam.
Give me 1 second. Yeah, you're good.
I'm getting that tour of the old jail.
I may give you the motion sickness.
Sorry.
Although it's as if I'm drunk, is the way it's falling. Okay. All right, can you hear me now, Mr. Kirk, or Mr. King?
Yes, Your Honor.
All right, good, all right. This case number 21 CR 56, State of Ohio versus Todd Lester Parr. Mr. Parr, you're appearing there from jail. All right. This hearing being conducted by Zoom. Mr. Parr's attorney, Dick Wagner, is present in his office, and Assistant Prosecutor King is present in his office on the panel that's actually marked by the iPad. Mr. Parr is charged with failure to register, change of address, and register sex offender or third-degree felony. Trial date is set for October 12th, and final pretrial is September 22nd. This is the first pretrial. I see that discovery has been provided by the state. Have you provided your discovery yet, Mr. Wagner?
I have not, sir.
All right. And we do like the final pretrial. And I also saw the Roosevelt papers also filed. Do you anticipate any pretrial motions?
I do not, sir.
Well, what we do, if any, by the final pretrial. Are you anticipating any, has been a written plea offer provided yet?
It has, Your Honor. If I may, I've taken my discovery out to my client along with the written plea offer. By no means are we locking ourselves into anything, but I think this matter's been resolved. Either I'll set it with Ms. Hoyer prior to the pretrial, or I don't want to use that date to clog up the docket. We'll find a date to resolve this matter, Your Honor.
All right. Any other matters to come before the court then, this time?
No, Your Honor.
All right, we'll see you then, next pretrial, if not before. Bart, thank you.
Thank you, Your Honor.
All right, Mr. Gammo, Michael John Gammo. Are you Michael John Gammo?
Yes, sir.
This case number 21-0109, State of Lappers, Michael John Gamble. Mr. Gamble is appearing by Zoom from the jail. Attorney is Dennis Kirby is present from his office, and then Mr. King, assistant prosecutor, is also present in his office. The iPad, or almost marked as his iPad now. This is pre-trial, final pre-trial set for September 23rd. Now I see that the state provided discovery of those particulars, and I see Mr. Kirby, you provided yours yet. I don't see any.
John, there should be a plea form.
Okay, that's what happened.
I brought it over to Bail Strain about 20 minutes ago.
Okay, must have left it at his desk. All right. Mr. Kirk, you and your client both agreed to waive presence in the courtroom and conduct this hearing by Zoom.
Yes, sir.
You're muted, Mr. Kirk.
Sorry, yes, Your
All
Honor.
right, and you do too, Mr. Gamble.
Yes, sir.
All right. All right, Mr. Gamble, I've been presented with a plea of guilty form. The state's going to withdraw your not guilty plea, counts 1, 2, and 3, and then pleads guilty. This is a 3-page form that the prosecutor's office prepared from a form they have on the computer. I'm going to hold this up to you, and this is, see your case number or your name on there, and a plea guilty form.
Yes, sir, Your
And
Honor.
you recognize that?
Yes, sir.
On page 3, there are signature lines, and about a third of the way down, there's a, maybe a quarter of the way down, there's a sentence that says, I enter this plea voluntarily. Beneath that, there's a signature defendant line, which appears to be Michael Gammo, or M. Gammo. Is that your signature there next to my finger?
Yes, sir, Your Honor.
And when did you sign this agreement, Mr. Gammo?
This morning.
All right. Did your attorney go over it with you before you signed it?
Yes, sir.
And did he explain it to you and answer any questions you had about it?
Yes, sir.
And have you been discussing this matter with him before going over this plea agreement this morning?
Yes, sir, Your Honor.
You think you've had enough time to fully consider this matter and make this decision?
Yes, sir.
And are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
Alright, now the agreement states on page 1 that you're going to withdraw your not guilty plea, plead guilty to counts 1, 2, and 3. Count 1 is failure to comply with order of signal police officer under 2921.331B of the Revised Code. A third-degree felony, receiving stolen property under 2913.51, which is a fourth-degree felony. And then third count is breaking and entering under 2911.13A of the Revised Code, fifth-degree felony. And further states that you understand the maximum penalties for those are as follows. For count 1, could be a period of up to 36 months in prison, but from 9, could be a fine of $10,000, and a license suspension is mandatory 3 years of life. Count 2, receiving stolen property, fourth-degree felony, possible prison term of 6 to 18 months, possible fine of up to $5,000. Count 3, breaking and entering, fifth-degree felony, possible prison term of up to 12 months, minimum of 6, fine of $2,500. Now, under the law, count 1, if you go to prison, is required to be served consecutively to counts 2 and 3. You could actually, if sentenced to the maximum, consecutive on all 3 counts, be sentenced to as much as 66 months. You understand that?
Yes, sir, Your Honor.
Are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently under probation, community control, parole, post-release control for a felony from any jurisdiction?
PRC.
TRC?
Yes, sir.
Alright, and, how much time do you have on TRC, do you know?
I believe it was 879 days.
Your Honor, there's a notice filed on July 21st. I believe that's July 20th. The notice had 879 days listed.
Okay, July, what date, July what?
21st was when it was filed.
Alright. There it is. 879 days as of, July 20th. So, let's see, that means there's been, since July 20th, there's been, 11, and today is the 1829 days, so that would mean, you have 850 days remaining, Mr. Gamble. And, so if you are convicted of a felon in this case and sent to prison, then, the court could also impose an additional 850 days as of today, and, whatever it is at the time of the sentencing, which would be served consecutive to the sentence for any of the other 3 counts. You understand that?
Yes, sir.
Alright. Now, under the law, if you are sentenced to prison, for these offenses and serve a prison term, for count 1, it is mandatory to be placed under post-release control for a period of 3 years. It's optional on counts 2 and 3, it's mandatory in count 1. That means you'll be supervised by a parole officer for 3 years under the term set by the parole authority. And if they determine that you have failed to comply, they can return you to prison even though you serve the maximum prison term imposed by the court for an additional period of up to 9 months for one violation, the maximum of half of your prison term for all violations. But if you commit a new felony while under post-release control supervision, then in addition, whatever sentence the judge in due case would impose upon you, the judge would also sentence, in this case, to an additional period of 1 year, or whatever time is that on that period of post-release control, whichever is greater. That occurs, that has to be served consecutively the sentence in the case. You understand that?
Yes, sir, Your Honor.
Right now, I'm not required by law to sentence you to prison for any of these offenses. I can give you what's called community control, which is what most people understand as probation. That means that instead of going to prison, you be put under the supervision of a probation officer for a period of up to 5 years and a term set by the court. If during the period of time that you're under supervision, the probation department tells you we're not complying, they would file a written notice at the court, serve a copy on you, and there would be a hearing which would be represented by an attorney. And if the outcome of that hearing was that you failed to comply, then at that time, the court would revoke your community control, then send you to prison for 66 months and fine you $17,500. You understand that?
Yes, sir.
Right now, count 1 of the indictment alleges that on or about May 8, 2021, in this county, you operated a motor vehicle as defined under ORC section 4501.01, so as willfully to elude or flee a police officer. After receiving a visible or audible signal from the police officer to bring the person's motor vehicle to a stop, and the operation of the motor vehicle by the offender causes substantial risk of serious physical harm to the person's property in violation, section 2921.33(b). So that's a failure to comply, the 3rd degree felony. Count 2 alleges on about May 8, 2021, in this county, you received, retained, or disposed of other property, certain property in a motor vehicle, as defined in ORC section 4501.01, the property of another Sullivan Show supplies, John Sullivan, Katie Cole, and that you knew or had reason to cause believe that obtained you commission of theft offense, violation section 2913.51. So that's the receiving stolen property, 4th degree felony. Count 3 alleges that on or about May 8, 2021, in this county, you did by force, stealth, deception, trespass in a building, East Main Street, Stoco, an occupied structure with purpose to commit therein theft offense, defined in ORC section 2913.01, or a felony in violation of 2911.13a, and revised code. And that's the 5th degree felony. Now, do you understand what it is you've been charged with in each of those cases, what the state says you did, when, where, how they alleged that you did it?
Yes, sir, Your Honor.
Have you discussed the nature of each charge, the evidence in the case, possible legal issues in the case, and possible defenses you might try to raise in trial, possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to get you to plead guilty?
No, sir.
Now, on page 2, there are 3 lines printed in bold that read, defendant shall enter plea of guilty to count 1, count 2, and count 3, state will dismiss count 4, and the state and defense will argue sentence, defendant shall pay full restitution on all counts. Is that your understanding of the agreement?
Yes, sir, Your Honor.
And does anyone promise you anything other than that to get you to plead guilty?
No, sir.
So you've not been promised if you plead guilty you're going to get any particular sentence.
No, sir.
And do we know what the restitution is, Mr. King?
Not yet, Your Honor. We're still working with the victims to try to figure that out.
Okay. All right. Now, do you hold any license or certificate from any state agency or any occupation or profession?
No, sir.
All right, now you have certain rights you must understand before I can accept your plea. First of all, you have a right to have an attorney, and if you can't afford to hire one, then the court will appoint one for you, and I did appoint Mr. Kirk. Now, the appointment wasn't simply to work the case out, but to provide whatever defense might be available to you under the law which you wish to provide. So, if you decide that you do not want to plead guilty, that you want to defend against these cases, he'll continue to represent you, including a trial, if that's what you want. You understand that?
Yes, sir, Your Honor.
Right now, under the Constitution, you have a right to have a jury trial in this case, in which, and all charges in which 12 people would be selected to serve on a jury from a group of citizens living in this county, summoned for jury duty on your trial date. After the 12 jurors were selected, the evidence would be presented, and then they would decide by unanimous verdict, meaning all 12 have to agree, as to whether or not the state proved your guilt by proof beyond reasonable doubt in any of these charges. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you could waive, which means give up the right to have a jury trial. In that case, you'll have to call it a court bench trial, meaning it would be the judge instead of the jury who would hear the evidence, apply the law, and decide whether or not the state proved your guilt by proof beyond reasonable doubt. You understand that?
Yes, sir, Your Honor.
Under the Constitution, you have a right to confront witnesses against you and cross-examine them for your attorney. What that means, the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions, that's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes, sir, Your Honor.
And under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify for you, same as the state. So, if you have witnesses you're not certain going to come in voluntarily, at your request, the court issues a court order called a subpoena, that force those witnesses to come to court to be able to testify for one of the two, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have privilege against self-incrimination, which means that you're not forced to give evidence in this matter or to testify against yourself at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even allowed to talk about it except one situation, that is if there's a jury trial you don't testify, the judge instructs the jury that the cause has your right to not consider it for any purpose. You understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent of each of these charges until proven guilty by the state of Ohio on every essential element of each charge by proof beyond reasonable doubt. What that means is the burden of proof isn't on you to try to prove you're not guilty of these charges simply because you've been accused. In fact, under the law, you don't have to present any evidence in your defense. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of each offense by proof beyond reasonable doubt. The highest burden of proof is known under the law. You understand that?
Yes, sir, Your Honor.
Right now, originally you pled not guilty to these charges. The plea of guilty denies allegations in the indictment, denies you committed a crime, and it exercises or revokes all of the rights I just described. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that they constitute a crime, admits that you're the one who committed that crime. And that plea waives, gives up all the rights that I've just described for you here today, except the right to have an attorney. You always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty waives, gives up the right to have a jury or court trial. Waives, gives up the right to confront witnesses against you and cross-examine for your attorney. Waives, gives up the right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. The wage gives up your privilege against self-incrimination because if you say you're guilty, that's what she finds guilty. And the wage gives up your presumption of innocence because if you say you're guilty, then that's what she finds you guilty, and the state doesn't have to approve it. Objection being sentenced immediately by the court, I think that's what should happen. Finally, the wage gives up any rights to file an appeal, which you think you may have had up to this point in the case. Now, I sentence you to the maximum sentence under other certain circumstances. You could file an appeal, but that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
And do you understand the 3 charges and possible penalties for each?
Yes, sir.
Do you have any questions?
No, sir.
Do you have any questions about the plea agreement?
No, sir.
You understand?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No,
Do
sir.
you understand?
Yes, sir.
Do you have any questions about the constitutional rights I explained?
No, sir.
Do you understand this?
Yes, sir.
Any questions you would like to ask Mr. Burke about? Before
No,
we go
sir.
further, if you need to talk to him, I can put you and him into a breakout room. So just the 2 of you can talk and there won't be anyone else that's listening or hear you or can see.
No, sir. I think you covered everything this morning.
Okay. Have any questions about anything I was playing?
No, sir.
All right, then this is your decision to withdraw your not guilty plea, plead guilty to counts 1, 2, and 3, pursuant to the terms of the plea agreement, which is going to.
Yes, sir.
All right, then as to the charge in count 1, which alleges that the on or about May 8, 2021 in this county, the operator of motor vehicles defined under RC section 4501.01 says willfully to elude or flee a peace officer after receiving a visible audible signal from a police officer to bring the offense motor vehicle to a stop, and the operation of the motor vehicle by the offender causing substantial risk of serious physical harm to person's property. That's a 3rd-degree felony, carrying possible prison term between 9 and 36 months, a fine of $10,000, and a mandatory license suspension of at least 3 years up to life. How do you plead?
Guilty, Your Honor.
Right, and as to count 2, which alleges that on or about May 8, 2021 in this county, received, retained, or disposed of certain property in a motor vehicle, as defined in ORC section 4501.01, the property of other Sullivan Show properties, John Sullivan and Katie Cole, and that you do have reason to cause to believe that obtained commission theft offense violation section 2913.51 of the Ohio Revised Code, a 4th-degree felony, carrying possible prison term between 6 and 18 months, fine of $5,000. How do you plead?
Guilty, Your Honor.
As to count 3, which alleges on or about May 8, 2021 in this county, you did by force, stealth, deception, trespass in a building, East Main Street, Sunoco, and an occupied structure for purpose of committing therein a theft offense, defined in section ORC section 2913.01 or felony, violation 2911.13A of the Ohio Revised Code, the charge breaking and entering a 5th-degree felony, carrying possible prison term between 6 to 12 months, fine of $2,500. How do you plead?
Guilty.
Alright, thank you. Court finding on this day of the court, defendants abide by most constitutional rights, made no intelligent voluntary waiver of the same. Pursuant to criminal 11, please accept the order filed, and is found guilty of the offense in counts 1, 2, and 3 as charged or in count 4 is dismissed. The court will order that a pre-sentence investigation be conducted, and sentencing will be set for September 22nd at 9 a.m. and bond will be continued. The probation officer will be in touch with you. You should make bond while awaiting sentencing. You have to report to the probation department immediately. Do you have any questions?
No, sir.
All right. Thank you.
Thank you.
All right. I'm going to do an arraignment on Likens, and then if you're coming over here, Mr. King.
Yes, Your Honor.
All right, so the jail is bringing Mr. Likens. You can go ahead and log off and come on over. All right, are you James R. Likens there at the jail? All right. Case case number 21 CR 215, State of Ohio versus James R. Likens. Mr. Likens, you were indicted by the grand jury of this county on August 3rd for aggravated possession of methamphetamine, alleging that on or about January 21st, 2021 in this county, you only obtained possession or used methamphetamine in over bulk amount less than 5 times bulk amount. That's a third-degree felony, which carries a possible prison term if convicted of between 9 and 36 months in certain increments provided by law, a fine of up to $10,000, and a possible license suspension of 6 months to 5 years. Now, you're entitled to have an attorney to represent you in this matter, and if you can't afford to hire one, the court will appoint one for you. And I see you have filled out a financial disclosure form. Is everything on this form correct?
Yes, sir.
When's the last time you were employed?
I'm employed now.
Where is that? Oh, Universal Forest Products and Land.
Yes, sir.
Okay. All right. How long have you been employed there?
About 4.5 weeks.
Okay. Is this the first time you've been in court on this case?
Yes, sir. I went to treatment when I got this indictment date. I signed a paper saying if you go to treatment, you won't be indicted. I signed it. I went to Massey House.
Wait. I asked, I don't understand what you're saying. Is this the first time you've appeared before any court on this case?
Yes, sir.
Okay. That's all I needed to know. All the rest of the stuff you had to say, I wasn't, not responsive to my question. I was just trying to determine if you've been represented previously on this charge by an attorney or not, which apparently the answer is no. All right. Court will appoint Attorney Catherine Hapner to represent you, and in the absence of counsel, I'll enter a not guilty plea on your behalf. All right, court will set for a bail review hearing for Friday morning, the 20th at 8:45 a.m. First pre-trial will be September the 1st at 1:00 p.m. Final pre-trial will be October the 6th at 1 p.m. And trial date will be October 25th at 8 a.m. All right, I was just looking at the CM report. I just see that the previous conviction for failure to appear and several other previous felony convictions. Over the last 15 years.
Ron,
All right. Yes.
I'm not sure what happened, but you completely like froze up, it disappeared, and then it came right back on.
I'm sorry, what's that now?
It's like you froze up.
Oh, okay, all right. I was just going through my court network's report that shows all the prior convictions that are addressed. So, can you hear me okay now?
I can hear you, but I didn't get no dates at all.
Oh, okay. August 20th at 8:45 for bail review. September the 1st at 1 o'clock for first pre-trial. October the 10th at 1 o'clock for final pre-trial.
October 6th.
October 6th, sorry. And October 25th at 8 a.m. for trial.
Okay, thank you.
All right, thank you. Bond will be set in the amount of $2,500 plus your own recognizance, Mr. Likens, which is your promise to appear. And if you fail to appear, you could be prosecuted for additional felony and is convicted. Sentence on that regardless of what happened in this case. You'll be required to pay a deposit of $171, statutory required fees. If you make the bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. You report to them immediately upon your release. You must report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing that they order by code numbers from home cell employer. If recommended by probation, be evaluated for substance abuse and mental health issues, the treatment indicated, enrolled in, and followed after and period of this action. You'll also be under house arrest at your residence at 1169 Day Route 31, meaning you have to be there all the time unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with a probation officer or attorney in this or any other case. And you also may attend any kind of schooling, GED classes, college classes, trade classes, job training, etc. You also attend church services. Other than that, you have to be there all the time. If you fail to comply, then the court could revoke that bond and have you held to a further order of the court. You have any questions, Mr. Likens?
No, sir.
All right. We'll notify your attorney and we'll have a hearing Friday morning on your bond. Thank you. Okay. All right, Greg Haynes.
I've heard your honor.
May. Okay, case number 21CR050, State of Ohio versus Drake Matthew Haynes. President of the state is Assistant Prosecutor Haynes. President of the defendant is Attorney Sarah Barber. And you are Drake Matthew Haynes. You need to keep your voice up there, Mr. Graham, so you're answering. All right. Matter set for an intervention in lieu of conviction. We don't have a PSI here. Defendant is charged with aggravated possession of methamphetamine and currently handling firearm motor vehicle. Motion was filed for intervention, and we were here last time. We didn't have final proof of his actual participation in the program, and I did receive facts this morning from Soda Payne Valley now, which indicates that he is in OD, SUD, substance abuse services, intensive outpatient mental health service. And looks like it started on August the 9th. So it looks like he's in good standing. All right. And how often are you going to a session?
3 times a week.
All right. All right. Now, Mr. Ames been presented with a plea of guilty form here, along with an entry that would put you in intervention in lieu of conviction program. This is a 4-page document the prosecutor's office prepared, and it has your name and says you're going to plead guilty to count 1 and 3, which is a forfeiture investigation. And it at the top of page 3, there's a sentence that says, I entered this plea voluntarily, and then below there, that there's a signature line with signature defendant. And that's your signature I'm looking at.
Yes.
When did you sign this agreement? Was it just today or was it before last night?
It was before last time.
All right. So, you understood when you signed this that this was an agreement to plead guilty, which means it won't be a trial. The next step in your case will be disposition of the case. It would be a trial. In other words, you understand that?
Yes.
Okay. Now, did you go over this agreement with your attorney before you signed it and have her explain it to you?
Yes.
Do you feel you had enough time to fully consider the matter before you made that decision? And are you entering into the agreement to plead guilty voluntarily? Right, now Mr. Ames, normally if somebody pleads guilty to a charge, they're sentenced. And that sentence can be a jail or prison term, it can be probation, it can be control, it can be a fine, or in this case could also be a license suspension since it's a drug offense, or any combination of that. And then after the sentence is imposed, that's filed in the case, and the case is completed, and then at that point you have a felony conviction on your record. Now, there is a procedure under the law for someone who has committed an offense primarily because of substance use disorder or mental health issues to plead guilty, but go into a program that's called intervention in lieu of conviction. That consists of a treatment plan by a certified treatment facility, which is why we needed that when we were here last week, and conditions of supervision through the probation department that are not as significant as if somebody was convicted and had the actual felony conviction. And so what happens is, if I put you into that program, then even though you plead guilty, you're not convicted because I don't sentence you. Instead of what I do is I stay in the proceedings. Stay is the legal term of meaning, will basically freeze or stop, and then it's put on hold. And then we wait for a report from probation and the treatment facilities how you're progressing in the program. Under the law, that program can be up to 5 years. I put people on for 2 years because I think that's enough time to find out whether or not the person's going to do what they need to do. And you have to comply with your treatment program. And one of the conditions is also that you cannot use any controlled substance or drug abuse unless you have a lawful prescription for that, or while you're on the program. And you also then have to comply with the conditions I set. And if you do that, and you also have to pay court costs and any programming fees might be incurred for the services. If you do that, then once the court's notified of that, the case is dismissed, even though you pled guilty. And you won't ever have a felony record because even if you plead guilty and it's in the file, you're not a felon until you have been sentenced. So you would never have been sentenced, and therefore the case will be dismissed. And then at that time, the court will set the matter for a hearing to seal the record, and that means that it will be removed from the court's files and no longer be a public record. And you can always tell people, no, I don't have a felony conviction. Now, that's the upside for you, because even though you're admitting you're guilty, you're not being convicted and found guilty and become a felon, and you have a chance to do this program. And if you do it successfully, then, like I said, you don't have a record. Now, the downside is this. You can't try this, and then if it doesn't work, come back and say, well, I want to have a trial now, because this is the only time you would have to go ahead and defend against the case, including a trial. And so, if you plead guilty, then the probation department will supervise you, like I said. If they decide, or they feel that you're not complying, or if they get the report that you have not completed treatment and left treatment or been kicked out of treatment, or if they find that you have been using drugs without a valid prescription, then they'll file a written notice out with the court. And we'll come back to court, you'll have a hearing, and we'll have an attorney at that hearing. If the outcome of that hearing is that you have failed to comply, then at that time you will be found guilty, and then you'll be sentenced, and you will have a felony record. Now, if you violate it, it doesn't mean that you're going to be sent to prison, because you could still be put under regular community control. And what that means is basically you can be supervised again for a period of up to 5 years under terms set by the court for convicted felons. Those conditions are more strict and are moral. And basically it works the same way, except that, again, and if the probation department feels you're not complying, then they file a written notice of it, we have a hearing, you can have an attorney, and if the outcome of that hearing is you fail to comply, then at that time, you'll be sentenced to 12 months and fined in $25,000. Now, do you understand that? Now, if that should happen, and you will serve a prison term, once that term is completed, the adult parole authority could also, as part of your sentence, decide to put you under post-release control supervision for a period of up to 3 years. And what that means is you'd be supervised under the conditions they set, because the court's not involved with that, by a parole officer for up to 3 years. And if they felt that you were not, or if they found, I should say, that you're not in compliance, they could return you to prison to serve an additional period of up to half of whatever prison term is imposed by the judge for all violations. However, if you commit a new felony while you're under that post-release control supervision, then in addition to whatever sentence the judge in the new case would impose upon you, the judge could also sentence you in this case to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. If that occurred, that then be served consecutively the sentence in the new case. You understand all of that?
Yes.
Okay, now the charge in this case, in count 1, alleges that on or about September 1, 2020 in this county, he did knowingly obtain, possess, or use a Schedule II controlled substance, to wit methamphetamine in violation of Section 2925.11 revised code. So that's the charge of aggravated possession of methamphetamine is a 5th-degree felony. Count 3 alleges that on or about the same date in this county, you had your possession of Smith & Wesson 9mm gun and a 9mm magazine, all subject to forfeiture due to this instrumentality in the commission or facilitation of the offense, as defined in Section 2941.1417 of the revised code. And that would result in the loss of that weapon to the state. There's no other penalty. Now, Mr. Ames, do you understand what it is you've been charged with in each of those counts, what the state said you did, when, where, how they alleged you did it?
Yes.
Have you discussed the nature of those charges, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise in trial, and possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with her advice and confidence in this matter?
Yes.
Now, are you under the influence of any types of drugs or alcohol at this time? Are you taking any prescription drugs? Has anyone threatened you to get you to plead guilty today? Other than being promised to be put into the intervention in lieu of conviction program, and having count 2 dismissed, has anyone promised you anything other than that to get you to plead guilty here today? Now, do you hold any license or certificate from any state agency or board for any kind of an occupational profession? Not a trade license from a trade organization or union, but
All right.
like something like a nurse's aide or engineering assistant or vet tech or something like that. Now, you have certain constitutional rights you have to understand before I can accept this plea of guilty from you. Because again, it's your last chance to stand on a not guilty plea and defend this case. So I have to advise you of these rights. First, you have the right to counsel. Mr. Barber was appointed to represent you, not simply to work the case out, but to provide any defense that could be available to you under the law that you would like her to provide. So if you decide you don't want to plead guilty, she'll still represent you and defend you, including a trial if that's what you want. You understand that? Now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be chosen from a group of citizens from this county that are summoned for jury duty on your trial day. Once they are selected, they would hear the evidence and be instructed on the law by the judge, and then those 12 jurors would have to decide by unanimous verdict, meaning all 12 would have to agree on a verdict to whether or not the state proves your guilt. Prove beyond reasonable doubt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means give up the right to have a jury trial. And then you would have what's called a court bench trial. That means that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, the judge would decide whether or not the state proved your guilt or proved beyond reasonable doubt. You understand that?
Yes.
Now, under the Constitution, you have the right to confront the witnesses against you and cross-examine through your attorney. So what that means Witnesses have to come in court and testify in front of you and your attorney and anyone else is present. Prosecutor's done asking questions, your attorney asks questions, that's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that? Now, under the Constitution, you have the right to use the power of the court, compel or force witnesses to come to court to testify for you, the same as the state. So, if you have witnesses you're not certain are going to come in voluntarily, your request for court issues a court order, that's called a subpoena. That forces those witnesses to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that? Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify will not be used against you in any way by any person at any time in the proceedings. No one's even allowed to talk about it except in one situation, that is, if there's a jury trial, you don't testify. The judge instructs the jury that because that's your right, they cannot consider that for any purpose. You understand that? Right now, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of each offense. So, if you decide, so therefore, under the law, you don't have to present any evidence that you're fancy simply because you're committed to. And again, at trial, you don't have to present any evidence because the burden is on you to try to show you're not guilty. The burden is upon the state to prove that you are guilty. And they must do that by proving beyond reasonable doubt on every essential element of each offense, which is the highest burden of proof that's known under the law. You understand that? Excuse me. Now, you originally entered plea not guilty. Not guilty plea denied the allegations in the indictment, denied you committed the crime, and exercised or invoked all the rights that I've just described for you. If you change your plea from not guilty to guilty, that is a complete opposite of not guilty plea. Guilty plea admits the allegations in the indictment, admits that they're a crime, admits that you committed that crime. And that plea gives up all the rights that I've just described for you, except the right to have an attorney. You always have a right to have an attorney no matter what you plead. But without exception, your plea is guilty. You waive or give up the right to have a jury or a court trial. You waive or give up your right to front the witness against you and cross-examine for your attorney. You waive or give up the right to use the power of the court, compel or force witnesses to come to court to testify for you, the same as the state. You waive or give up your privilege against self-incrimination because if you say you're guilty, that's what you find you guilty. But also waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove it. It also subjects you to being sentenced immediately by the court. And finally, waives or gives up any right to file an appeal that you think you could have had up to this point in the case. Now, if I were to sentence you the maximum sentence under other circumstances, you might be able to file an appeal, but you have to file in 30 days of your sentencing entry being filed. Do you understand all of that?
Yes.
And are you a U.S. citizen, Mr. Ames?
Yes.
Now, do you have any questions about the intervention lieu of conviction program? What will be required of you? You understand?
Yes.
Any questions about the first and third counts of the indictment or possible penalties? You understand?
Yes.
You have any questions about the plea agreement? You understand it?
Yes.
Have any questions about the constitutional rights of the claim? You understand those?
Yes.
Have any questions about the plea of guilty, what it means, what will happen if you enter that here today? You understand?
Yes.
Is there anything you need to speak with Ms. Barker about before we go further? Have any questions about anything I've explained to you? Is it your decision, Mr. Ames, to withdraw your not guilty plea and plead guilty to the charges that I've just gone over with? And as to the charge in the first count of the indictment, which alleges that on or about September 1, 2020 in this county, he did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine in violation of Section 2925.11 of the Revised Code, a charge of aggravated possession of methamphetamine, a fifth-degree felony, for a possible prison term between 6 and 12 months, possible fine of up to $2,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
Then as to count 3, which alleges on or about September 1, 2020 in Highland County, Ohio, you had in your possession Smith & Wesson 9mm gun, serial number stated in the indictment, and a 9mm magazine, all subject to forfeiture due to this instrumentality of conviction, facilitation, and offense. Fine under 2941.14.17. How do you plead that? Great, thank you. Be seated. All right, the court finds that on this day in open court, the defendant was advised of all his constitutional rights, including knowing, help, and voluntary waiver, same pursuant to criminal 11. Plead guilty is accepted and is ordered filed. Now, the court further finds, after receiving the information today and reviewing the PSI that was presented previously, that the defendant's drug dependence was a factor that led to the criminal activity of which he's been charged, and rehabilitation through treatment will substantially reduce likelihood of future criminal activity. The court finds he has been accepted into an appropriate certified treatment program and so can valid mental health. Is otherwise eligible for controlled sanctions, is not a repeat or dangerous offender, and is otherwise eligible for intervention in lieu of conviction under 2951.041 of the Revised Code. Therefore, the court orders that his plea of guilty be accepted and filed as previously stated, but the court will stay the proceedings in the matter at this time and will not enter a finding of guilt. The defendant will be under the supervision of the control under probation department for a period of 2 years. Those terms will be given to you, Mr. Ames, and I previously approved those. You're also required to complete an intervention plan and so to take valid mental health, including aftercare. And also, particularly, you must abstain from using drugs or alcohol for a period of 1 year. And you're required any other conditions or terms that the probation department may require, including any further treatment that might be considered appropriate after it's been evaluated. Now, if you're also ordered to pay the court costs. Now, if you successfully complete the intervention plan and comply with all other conditions of control, then the court, upon receipt of that, will dismiss the charge, be pled guilty, will not be found guilty, and the case will be closed, and the court will set the matter for a sealing hearing. And unless there's something that would happen between those 2 days, it's almost guaranteed it will be sealed. However, if you fail to comply with any of these conditions I've ordered, or any of the conditions of the probation department, or the treatment plan that you have, or if you use drugs or alcohol within 1 year of this order, then at that time the court will, there'll be a written notice of that file with the court. You'll be given a copy of it. There will be a hearing. You will have an attorney. And if the outcome of that hearing is that you fail to comply, then at that time the court will terminate you from the intervention program, find you guilty, and enter a finding of guilty, and then sentence you. As I said, that could then be 12 months in prison, fine of $20,000, and a license suspension of 6 months to 5 years. All right, is there anything further from the council?
No, Your Honor.
All right, you're no longer under the pretrial supervision, house arrest, and so forth. You're off of that. You're under the new conditions. Mr. Arjun is over here. You need to see him, and then he'll set up stuff for you to go over all those conditions and everything. And if he hasn't already, and we'll be transferred to that. All right, thank you.
Thank you.
Mr. Hill?
I was gonna ask Eric if that's all the things.
Okay.
Your Honor.
Sheriff Hill. Case number 11CR85. President of the state is Prosecutor King, present for the defendant, Attorney Sarah Harder. Mr. Hill is not present.
Your Honor, I apologize. He is present, however, he's not dressed appropriately.
Okay. All right, well, I'll give him 30 minutes to go down to Family Dollar or get something to put on and come back. Or just go to jail. Yeah, he was supposed to report the day after at 4 o'clock. He reported at 3:58. He's told to come back on Monday, and he didn't. So tell him the ice is real thin and it's cracking all around him. So 30 minutes, I can see back here appropriately dressed.
I will let him.
Thank you. Oh my God. Yes,
I wish my client was a family dollar. He might be in Lexington, Kentucky.
so your guy's not up till, who's your guy?
Shoemaker, status here.
He's not, oh yeah, 2 o'clock.
He's got 2 minutes.
You got 2 minutes. Actually, 1 minute, I'm done. Was 1 minute and 10 seconds, now it's 1 minute.
I'll take bets.
Yeah. Okay. Case number 20 CR 147, State of Ohio versus Thomas Neal Shoemaker Jr. Present for the state is Assistant Prosecutor King. Present for the defendant is Attorney Jacob Wagner. Mr. Shoemaker is not present. Mr. Shoemaker was in custody and was granted a furlough on July 17th due to alleged cardiac issues. And he was at Clinton Memorial, so the court brought order that he was to immediately report back to the jail on his discharge. The entry went on the 19th, the 17th, I believe, might be on, that was on a Saturday, I should remember that. My wife suffered a spinal compression fracture. And so he is not reported back to jail. The court did grant his attorney's motion to continue the trial date set for 12. But Mr. Wagner, have you heard anything from your client?
I have not, sir. Nothing in the file indicates he's contacted my office. I did contact intake at the jail today. He was not booked at Highland County Justice Center. They had not had any contact. Last thing they knew is he had gone from Highland District Hospital to Memorial, and that is it, sir.
Well, that's been over a month ago. And I seriously doubt that he's still in the hospital. Have you tried to contact him?
I'm not. I'll call. If I wouldn't tell me this is in the.
Yeah. No, most likely. Do you have a number for his family or anybody?
I've got 0, Your Honor.
You know anything about his family, Mr. Archibald?
I had when he was out of municipal, And the only number I had was an attorney.
Was it what?
It was an attorney. This has been maybe a year.
This was the guy, the old gentleman that showed up with the briefcase saying he was jumping on.
That guy? You know?
Remember that case?
Yes, I do.
But I don't think the guy was a registered valid attorney in the state of Ohio anymore. Something was odd about it.
Yes. I'm trying to remember now what that was. I think he was either inactive or he wasn't licensed on that.
Pike County, wasn't it?
Oh, yeah, that's right. But he was inactive, I'm pretty sure. Yeah. And, he was there as an advisor.
Yeah, called the
A
court.
family advisor.
Called the court, said he was the attorney or something crazy like that, or?
Well, yeah, he said that, he wanted to have a hearing. On his phone, because he was gonna be late, and we said, well, who are you? And, said, you're not the attorney of record, so you're here, you can be in the courtroom, but they're not going to get it. So, is that on this case?
I think so. He popped his briefcase and there sat one little business card.
Well, that guy, as I recall, is a friend of the family.
That was his emergency contact, was his attorney.
Okay, yeah, here, well, this is interesting.
You want this on the record, Judge?
Yeah. Guy's name is James, can't read his name.
Chandler?
Chandler, that's it. And he sent a letter to the clerk on June 16th with a handwritten fax. He was that time at the SOMC hospital, obtaining medical records regarding his client, Tom Schmidt. Missed a hearing this morning because he was in the hospital. So, you still have that number?
In the system.
Okay. Yeah, I tell you what, we'll go ahead and recess the hearing. I'll give it till tomorrow afternoon to get in touch with Mr. Chandler. And have Mr. Chandler put you in touch with his family and find out where he is. So, I'll be interested in hearing. Because he's also on a $10,000 bond. Yeah. Okay.
Chandler is the attorney. Chandler is who the clerk's office has listed on the docket as his attorney.
Oh, okay. Hey, they have his name listed on the docket because he filed that motion even though he wasn't the attorney of record. Or he didn't file a motion, it was a letter, the facts, and they went ahead and put it on the docket that way, for whatever reason. But he's out of Pike County, and I'm thinking there's some history there. I'm thinking maybe, well, we're done. All right. Case number 21 CR 085, State of Ohio versus Jared Pitt, Jared Arnold. President states as prosecutor and President defendant attorney Sarah Carter. Are you Jared Arnold?
Sir.
Arnold is charged with aggravated trafficking methamphetamine and aggravated possession of methamphetamine. This is a pre-trial, the final pre-trial, I believe the second trial, and the second trial. I have been presented with a plea of guilty for Mr. Hill. Says you're going to withdraw your not guilty, plead guilty to count 1, the indictment. Now this is a three-page form that's been prepared by the prosecutor's office from a form in their computer. And on page 3, there, about a third of the way down, is a sentence that says, I enter this plea voluntarily. Right below that, there's a line with a signature defendant printed below it. It looks like the signature is Jared Hill. Is that your signature I'm looking at here?
Sure.
And did you just sign this agreement?
Yes, sir.
Now, when you signed it, did you understand it's an agreement to plead guilty, which means there won't be a trial, and the next step in your case will be sentencing?
Yes, sir.
And do you think you've had enough time to fully consider this matter for making this decision?
Sir.
And had you talked to Ms. Barber about that before today? You were here before?
Yes, sir.
All right. So you're not, you don't feel you're being rushed or pressured in any way in doing this?
No, sir.
Entering into the agreement to plead guilty voluntarily.
Yes, sir.
Now, the agreement says you're going to plead guilty to the first count under 2925.03A1, a 4-3 felony. Further states that you understand that the maximum prison term, that if prison term imposed could be up to 18 months, minimum 6 months. It could also be a fine of $5,000. And there's a possible license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Do you face any felony charges anywhere else?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
Yes, sir.
Right now, under the law, if you are convicted of this offense, and if you are sentenced to prison, once you serve the term imposed by the court, the adult parole authority has the right, if they choose to exercise it, to put you under what's called post-release control supervision for a period of up to 3 years. So it's optional, it's not mandatory, so they'll make the decision. If they decide you should be supervised, you'll be supervised by a parole officer in the terms they set. If they determine that you have failed to comply, then they can return you to prison even though you served the entire term that was ordered by the judge. Make you serve up to half of whatever prison term was imposed for one or more violations. But if you committed a felony while under post-release control supervision, then in addition, whatever sentence the judge in the new case would impose, that judge could also sentence you in this case to an additional period of 1 year. Whatever time left on 3 years of post-release control, whichever is greater, if that occurred, that would have to be served consecutively with the sentence in the new case. You understand that?
Yes, sir.
All right, Mr. Hill, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called non-prisoner community control sanctions. That means that you would be supervised for a period of up to 5 years on a term set by the court, by the probation department. And if during that time they felt that you were failing to comply, then they would file a written notice out to the court. There would be a hearing, and you would be entitled to have an attorney to represent you at that hearing. And if the outcome of that hearing was you failed to comply, then at that time, the court would revoke your community control and sentence you to prison for between 6 and 12 months and fine you $2,500. Do you understand that?
Yes, sir.
Now, the charge in the case alleges that on or about November 18, 2020, in Huntington County, Ohio, did knowingly sell or offer to sell methamphetamine in a Schedule II controlled substance. And so that's the charge of aggravated trafficking methamphetamine. And I think I misadvised you. It's a 4-3 felony, so it's 6 to 18 months. I think I said 6 to 12 months, 6 to 18 months. You understand that?
Yes, sir.
All right. Now, you understand what it is you're charged with, what the state said you did, how they alleged you did it?
Yes, sir.
You understand the possible penalties.
Yes, sir.
Right. Now, you discuss the nature of the charge, the evidence of the case, possible legal issues of the case, possible offenses you might try to raise in trial, possible outcome of the trial with your attorney.
Yes, sir.
Are you satisfied with your advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
You taking any prescription drugs?
No, sir.
Have any expressed medication you plead guilty?
No, sir.
Right now, on page 2, there are 3 lines that are printed in bold and underlined, so I'll read those. Finish on or plea of guilty to count 1, state dismiss count 2, state will not oppose to control and substance abuse treatment based on HB 86. Finish shall pay restitution $60 as part of consideration for plea agreement. Is that your understanding of the agreement?
Yes, sir.
Is that what pops in? Other than that, if you could go here today.
Yes, sir.
Now, under the law, I don't have to follow the recommendation of the sentence because the sentencing is done by the judge, not the parties. So even though there's an agreement, that should be your sentence. Once I've received all the information and reviewed everything, if I decide that's not the correct sentence, you could be sentenced to prison for between 6 and 18 months and fine $5,000. You understand that?
Yes, sir.
Now, do you hold any license or certificate from any state, board, or commission for any kind of occupation or profession?
No, sir.
You have certain constitutional rights, you must understand, before I can accept a guilty plea from you. First, you have right to counsel. Barker is your attorney. I did not appoint her simply to work the case out, but to provide any defense that might be available to you under the law, which you would like to provide. So, if you do not want to plead guilty, but you want to defend against this case, then she will continue to represent you at trial if that's what you want. You understand that?
Yes, sir.
And under the Constitution, you have the right to have a jury trial in this matter, Mr. Earl, which 12 people will be selected from a group of citizens that live in this county, summoned for jury duty on your trial date. After they were selected, they would be instructed on the law. They would receive the evidence and then be instructed on the law. And then they would have to decide by unanimous verdict, all 12 would have to agree whether or not the state proved your guilt or proved the unreasonable doubt. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial. And in that case, you would have to call it a court or bench trial, meaning that it would be the judge would hear the evidence instead of the jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt or proved the unreasonable doubt. You understand that?
Yes, sir.
Under the Constitution, you have a right to confront witnesses against you to cross-examine through your attorney. That means that witnesses against you would have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney has the right to ask questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Now, under the Constitution, Mr. Hill, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're uncertain going to come in voluntarily to request court issue court order, that's a subpoena, you have to force those witnesses to come to court, be available to testify if you wanted them to, though they don't want to be here. Which is the same way the state's witnesses are forced to come to court. You understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter against yourself at any time through the trial. No one could ever make you testify. The prosecutor can't, the judge can't, you make that decision. If you decide not to testify, the fact that you did not testify is not used against you in any way by any person. No one's even allowed to comment about it except in one situation. That is, if there is a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Right now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio by proof beyond reasonable doubt on every essential element of the offense charge. What that means is the burden of proof isn't on you to prove you're not guilty simply because you've been accused. The burden's on the state to prove you're guilty. In fact, at trial, you're not even required to present any evidence. Now, you may, but you're not required to, whether you do or not. The burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof known under the law. You understand that?
Yes, sir.
Now, originally entered a plea not guilty, Mr. Hill. That plea denied the allegation of the indictment, denied the crime, and exercised or invoked all the rights that I just described for you. If you change your plea from not guilty to guilty, that is the opposite of not guilty plea. Guilty plea admits the allegation that the indictment admits that their crime is committed that crime. And that plea waives gives up all the rights that I've just explained for you, except the right to have an attorney. You always have a right to have an attorney no matter what you plead. That exception. Plea of guilty waives gives up the right to have a jury or court trial. Waives gives up the right to confront witnesses against you, cross-examine with your attorney. Waives gives up the right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state. It waives gives up your privilege of self-incrimination because if you say you're guilty, that's what you define as guilty. It waives gives up your presumption of innocence because for safety, because the state doesn't have to prove your guilt. And finally, it waives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I sent you the maximum sentence or other circumstances, file an appeal, I would have to be filed within 30 days for your sentencing if you're being filed. You understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Right now, do you have any questions about the charge or possible penalties?
No, sir.
You understand?
Yes, sir.
Do you have any questions about the plea agreement?
No, sir.
You understand?
Yes, sir.
You understand the court was not bound by the plea recommendation?
Absolutely, sir.
Do you have any questions about the constitutional rights of the plea?
No, sir.
You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, and what will happen if you enter here today?
No, sir.
You understand?
Yes, sir.
Anything you'd like to speak with your attorney about before we go any further?
No, sir.
Do you have any questions about anything I was explaining to you here today?
No, sir.
And is it your decision to withdraw your not guilty plea, plead guilty to the charge in accordance with the plea agreement we just gone over?
Yes, sir.
Right? Then as to the charge which alleges that on or about November 18, 2020, in Highland County, Ohio, you did not only sell or offer to sell methamphetamine, Schedule 2 controlled substance in violation of section 2925.03A1 Driverwise Code, a charge of aggravated possession of trafficking of methamphetamine, a fourth-degree felony, carrying possible prison term between 6 and 18 months, fine of $5,000, and a possible license suspension of 6 months to 5 years.
Okay.
Thank you, we see. All right, the court finds that on this date, open court, the defendant was advised of all his constitutional rights and made no intelligent voluntary waiver of the same pursuant to Rule 11. Pleas accepted or filed, defendant is found guilty on count 1. Count 2 is dismissed. The court ordered a pre-sentence investigation, including assessment for substance use treatment, disorder treatment, mental health. Sentencing will be held September 22nd, I believe, at 9 a.m. Yes, 9 a.m. Bond will be continued. Now, Shahel, are you living in Hillsborough or in Cincinnati?
I'm staying with my brother in Cincinnati, but my boss, I work for a footer company, and he's the one that's been bringing me back and forth. So I go to work every day, and if I have today I had a court date today, and he brought me up here. He's actually at Lowe's waiting to see if I was able to go home or.
Okay, all right. Well, see Mr. Arjima after this, you're gonna have to make an appointment to come back and be interviewed for your pre-sentence report. You're also gonna need to be assessed, but if you're living in Cincinnati, you're not gonna be able to get the treatment here, so you're gonna have to be, get in touch with the program down there, so, when they talk to you at the probation department, they'll tell you about that. They'll assess you, but, you won't be able to get treatment here, because you're gonna be in the Cincinnati area, you need to be down there.
I'm sorry, I didn't mean to push this. I apologize. I've been working, I've been saving up money to get an apartment so I can be closer, come back home. And I'm almost close, and I'll try to speak to my boss and see if he will loan me the rest, get an apartment down here. But
Okay, well,
I can, if I need to get an assessment down here, I can do that.
well, you talk to the probation department, they'll work with you on that, because, you'll have to be assessed in the county where you reside.
Okay.
All right. I'm gonna get a assignment notice from the bailiff, and I'll be here on the 26th. Make sure you report.
Okay. Thank you, sir.
Thank you. Get your assignment notice and go see the bailiff. number 21 CR 75, State of Ohio versus Silas Poet. Present for the state is the assistant prosecutor King, defense attorney Lunstein. You, Silas Poet.
Yes, sir.
Right, first pretrial, I believe, the defense charged illegal conveyance of drugs for use on the ground specified government facility at Burberry Lane, aggravated possession of drugs and fifth degree felony. Final pretrial set for 1st of September, and the trial date is the 23rd of September. All right, we've been presented with a plea of guilty, a diversion program, and a vet entry referral to diversion. The defendant's completed the agreement at this prosecutor's office.
Correct, Your Honor.
Okay. All right. All right, Mr. Pulliam, I have this 3-page agreement here that indicates you're going to withdraw or not go to plea guilty to count 2 of the indictment. I believe it means count 1 will be dismissed. Yes. And there are signature lines on this document. Page 3, there's a sentence at the top reads, I entered this plea voluntarily. And it looks like there's a signature immediately below that, Silas E. Poole. Is that your signature I'm looking at here?
That's correct, Jim.
And did you just sign this agreement today?
Yes.
All right. And did you go to the attorney before you signed it?
Yes.
And did you understand that by signing this, you're pleading guilty, which means there won't be a trial, and the next step will be the disposition of your case?
Yes.
Okay. Now, under the law, Mr. Pulliam, when a person pleads guilty, typically they are found guilty. And if it's a felony, then there's a sentencing hearing. And once that person is sentenced, could be term of imprisonment, could be a fine, could be a license suspension in this case, or any combination of those. Could be community control, which means probation. And then once that happens, you're found guilty and you're sentenced, you then have a felony conviction. Now, there is a program that's available, called diversion, and we have established one of those in this county a number of years ago. And what that program provides is if a defendant pleads guilty, they have the right, or they have the opportunity, if the prosecutor is willing, to enter into an agreement with the prosecutor's office, basically a contract. And you have certain obligations that you're to perform. As I understand it, you signed that agreement and paid a $150 fee. So you're aware of what that agreement is?
Yes.
Okay. And if you perform all of your obligations under that agreement within the time frame of that agreement, then the prosecutor notifies the court, and even though you pled guilty, the case is dismissed, because if you go in a diversion program, I don't find you guilty, I'll accept your plea, but I don't find you guilty, I stay the proceedings, and then we'll wait for the report. And if the report's good, the case is dismissed, and the court will seal the record, unless there's a reason not to. And that means that even though you pled guilty, you've never been convicted, because I never found you guilty and I never sentenced you. The diversion order is not a sentence. So that's the upside for you in this situation. You get the opportunity to, even though you're pleading guilty, to avoid being convicted and having a felony record. Even if you do this while you're in the program, if somebody looks up and says, well, you pled guilty, so you must be convicted, you're not convicted until I sentence you. And then at that time it's final, then you're convicted. So you just tell people that I'm in a diversion. So that's the upside for it. Now, here's the downside. The prosecutor's office administers the program, and they're the ones that determine whether or not you comply with the agreement. And if they determine that you're not complying, and they feel that there's no reason to justify any failure to perform, you notify the court, and then you come back here and you're found guilty. Because whether or not you're performing in good faith is such that it's a matter of privilege, not right. And so, if they tell the court that you failed to comply and come back, find you guilty, and then we'll most likely order a pre-sentence report, then there will be a sentencing hearing. And you'll be represented by counsel at that time. And if you can't afford to hire an attorney at that time, court will appoint one for you. Now, that means then, once I determine that you felt that the prosecutor has properly terminated you, then you are now guilty, you are sentenced, and then at that point, you have a felony record. Now, at that time, I wouldn't necessarily sentence you to prison, because again, that's the first time being convicted, and so you could get community control or probation, which means you be supervised for a period of up to 5 years, under term set by the court by a probation officer. And if during that period of time that you're being supervised, they felt you were not complying, they would have to file a written notice of that with the court, give you a copy. You'd be entitled to have a hearing to contest that, and have an attorney to represent you in that hearing. And in the event that the court then found that you were not complying, then at that time the court would revoke your community control and then send you to prison for 12 months. And it could be between 6 and 12 months. Fine you $2,500. You understand that? Now, in the event that should happen, then once you complete the prison term set by the court, the law goes on to provide that the adult parole authority has the authority under the sentence imposed by the court to put you under what's called post-release control supervision once you complete the prison term for a period of up to 3 years. And if they do that, you'll be supervised on the terms that they set by parole officer because the court has no involvement with that. If they determine that you have failed to comply, then they can return you to prison, even though you served the entire term set by the court, for an additional period of up to, in this case, 1/2 of whatever sentence was imposed by the court, for one or more violations. But if you commit a felony while you're in post-release control, then an additional whatever sentence the judge in the new case can impose upon you. The judge could then also sentence you for committing that crime while under post-release control in this case, to an additional period of 1 year, whatever time is left upon that period of post-release control, whichever greater. That occurred, that would have to serve consecutively the sentence in the new case. You understand that?
Yes.
All right, now, the charge in this case alleges that on or about October 3, 2020 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with hydrocodone, violation section 2925.11 of the Ohio Vice Code. So that's the charge, so aggravated possession of drugs that you found. Now, Mr. Foley, you understand what it is you've been charged with, what the state said you did, when, where, how, and that you did?
Yes.
And we discussed the nature of that charge, the evidence in the case, the possible legal issues in the case, the possible defenses you could try to raise in trial, and possible outcomes of a trial with your attorney.
Yes.
And are you satisfied with his advice and confidence in this matter?
Yes.
And are you under the influence of any types of drugs or alcohol at this time?
No.
Do you take any prescription drugs?
Yes.
For what?
I have allergy prescription medicine. I have an anxiety medicine and ADHD medicine.
Will any of those medications interfere with your ability to understand what you've read or been told or to communicate or to understand what I'm saying here today?
No.
Okay, you've understood everything?
Yes.
If there's anything you don't understand, just tell me, we'll explain it for you, okay? All right. Have any threat to make you plead guilty here today?
No.
Now, other than being promised to be placed in a conversion program rather than be sentenced, found guilty and sentenced, and to have your count 1 dismissed, has anyone promised you anything besides that to get you to plead guilty here today?
No.
Right now, since this is your last chance to stand on a not guilty plea and to have a right to trial, or you need to understand what rights you're giving up because you're pleading guilty. So, first of all, you have the right to counsel. You employ Mr. Munstein to represent you. Now, under the law, if you couldn't afford to pay for counsel, or that would appoint counsel for you, then no cost. So, the only reason I bring that up is you're not entering into this agreement because you have concerns about being able to pay for Mr. Munstein's services. You're not, that's not a problem. Okay. All right.
Yes, you're correct.
Now, you have certain constitutional rights in addition to that. First of all, you have a right to have a jury trial in this matter. That means you have a right to have a trial of 12 people, by jury, opposed to 12 people that are selected from people who are summoned for jury duty on your trial date to reside in this county. Once 12 of those Highland County citizens were selected, The evidence will be presented, then be instructed on the law. Then that jury will decide by unanimous verdict between all 12 and after agreed whether the state proved your guilt of the charge. Now, if you didn't want to have a jury trial, if you didn't want to plead guilty, you can waive, which means give up in writing, the right to have a jury trial. In that case, you would have what's called a court or bench trial. That means that instead of the jury hearing the evidence, it would be the judge who hear the evidence. The judge would apply the law. The judge would decide whether or not the state proved your guilt by proving beyond a reasonable doubt. You understand that?
Yes.
Now, under the Constitution, Mr. Pulliam, you have a right to confront the witnesses against you and cross-examine them through your attorney. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and then everyone else is present. After the prosecutor's done asking questions, your attorney asks questions, that's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes.
Right now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court and testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, that's a subpoena, and that forces those witnesses to come to court to testify for you, even though they don't want to, which is the same way the state's witnesses are required to testify. You understand that?
Yes.
And again, and maybe you didn't hear it also, but go back to the previous one, just make sure it's clear that you heard it all. And that is that you have a right to confront witnesses against you and cross-examine for your attorney in open court. So those witnesses will have to come into court and testify in front of you, your attorney, and everyone else is present. Now, if the prosecutor's done asking questions, your attorney will ask them questions, cross-examination, the purpose of which is to bring out evidence that helps your side of the case. You understand that?
Yes.
Now, under the Constitution, Mr. Pulliam, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even allowed to comment about it, with one exception, and that is if there's a jury trial and you don't testify, the fact that you did not testify cannot be used against you in any way, at any time in the proceedings by anyone. And in fact, no one's even allowed to talk about it or mention it in the case, with one exception, and that is if there's a jury trial and you don't testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes.
Now, under the Constitution, Mr. Pulliam, you are presumed innocent of this charge until proved guilty by the state of Ohio on every essential element of the offense. So that means that the burden of proof isn't on you to try to prove you're not guilty. The burden is on the state to prove that you are. And they must do that by presenting evidence on every essential element of the offense charged. And prove it by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. And you don't have to present any evidence at all. You understand that?
Yes.
Now, you originally pled not guilty. Not guilty plea denied the allegations in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is the complete opposite of not guilty. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. That plea waives or gives up all the rights that I've described for you today, except the right to have an attorney, which you always have no matter what you plead. But without exception, your plea of guilty would waive and give up the right to a jury or a court trial. Waive and give up the right to confront witnesses and to cross-examine for your attorney in open court. Would waive and give up the right to use the power of the court to compel witnesses to come to court to testify for you by subpoena, the same as the state.
They shouldn't have many trucks left.
Yeah, I was going to say it. It's all be out of the building now. Alright, the plea of guilty waives, gives up your right to confront the witnesses on the witness stand and have them cross-examined for your attorney. Waives, gives up the right to use the power of the court to compel them to come to court, witnesses to come to court to testify for you like the state. The waives, gives up your privilege of self-incrimination because you're saying you're guilty, that's what she finds you guilty. The waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove that you're guilty. It also subjects you to being sentenced immediately by the court And finally, a waiver gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence under other circumstances, you can file an appeal. That would have to be filed within 30 days of the sentencing entry being filed. You understand all that?
Yes.
And Mr. Foley, were you a U.S. citizen?
Yes.
Now, do you have any questions about the diversion program or what's the expected new diversion contract?
I do not, sir.
You understand?
Yes.
You understand it's the state will determine, the prosecutor's office will determine whether you're compliant.
Yes.
Do you have any questions about the charge and possible penalties in count 2?
No.
You understand?
Yes.
Any questions about the plea agreement?
No.
You understand it?
Yes.
Any questions about the constitutional rights I've explained to you?
No.
Understand those?
Yes.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No.
You understand that?
Yes.
Is there anything you need to speak with Mr. Bernstein about before we go any further?
I don't think so. No.
You have any questions about anything I explained to you today?
I do not.
Then is it your decision to withdraw your not guilty plea and plead guilty to count 2 of the indictment in exchange for being recommended to be placed into the diversion program instead of being sentenced?
That is correct.
All right. And as to the charge which alleges in count 2 that on or about October 3, 2020 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule 2 controlled substance with hydrocodone, violation of Section 2925.11 of Higher Vice Code, a 5th-degree felony, carrying possible prison term between 6 and 12 months, and a fine of $2,500, along with possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
DBC, thank you. All right. Court finds that on this date, in open court, the defendant was advised of all his constitutional rights and made no intelligent voluntary waiver save for such criminal 11. Please accept it in order to file. The court finds that pursuant to 2935.36 of the Higher Vice Code, there's nothing that renders this defendant ineligible to participate in the Highland County Prosecuting Attorney Diversion Program, and therefore grants the defendant's request for admission into that program. So there will be no finding of guilt made at this time. The guilty plea will be filed and held pending in advance, pending the report from the prosecutor's office regarding the defendant's program progress in the program. You're to pay the court costs, of course, the terms of the agreement. The court finds you have to pay the participation fee, and you'll also be required to pay any programming fees that might be required under the supervision conditions of the probation department. And the arresting officer has been notified of the disposition of this case, Mr. King.
Yes, Your Honor.
All right, so this will close the case then. For the time being, Mr. William, as I said, the guilty plea will be a record that you do not have a felony conviction, and you'll no longer be under the pretrial supervision conditions, house arrest, and other things. Report immediate information, see probation department, but probably be Mr. Argina, your pretrial supervision officer. And he'll set up we'll do it today, or they'll come back, and he'll set up a kind of the overall conditions and the requirements of the program, and have you sign off on it so that they can transfer the supervision over to that department. All right. Anything from the council?
No, Your Honor. No, Your Honor.
Do you have any questions, Mr. Foley?
I do not.
All right. Then go ahead and report meeting down probation. Thank you.
Thank you.
Please rise.
Thanks a lot. Thank you. Yep, nice to meet you guys.